Ron?
Yep.
Great. So for those who don't know me, my name is Michael Kuzma. I'm a solo practitioner in Buffalo, New York. In addition to practicing law, I'm also involved in democratic politics. I worked on Dennis Kucinich's campaign. I worked for the Erie County Legislature, and I also worked for the Buffalo Common Council. I've run for public office on a number of occasions without success, unfortunately. And I represent Leslie James Pickering, former media person for the Earth Liberation Front, represented Leonard Peltier, Native American activist to political prisoner, who's been incarcerated for over 39 years for shooting deaths of two FBI agents. I also represent Anthony Bottom, now known as Khalil Montekim, who's been in prison for over 40 years for his involvement with the Black Liberation Army and the Black Panthers. But today what we'll do is we'll talk about the Federal Freedom of Information Act, or FOIA for short, and for New Yorkers in the room, our state law, which is the Freedom of Information Law, FOIA, was modeled after the federal statute, and there's some very slight differences, but the exemptions are pretty much the same. The only real differences that we can get into them are the number of days an agency has to respond. But just briefly, it's always good to reinforce things by the written word. The FOIA was passed, or signed into law actually, on July 4th, 1966 by President Johnson. And the law was actually amended in '74 as a result of the Watergate scandal and some of the revelations about the FBI's counterintelligence program and the Church Committee. Now, the law was actually strengthened over a veto by President Ford, because he was not a big fan of the strengthening of the statute. Now, in '86, the law was amended yet again, compliments of President Reagan. And just as an aside, I called President Reagan President Bonzo at CUNY Law School, and I got a little lawsuit student upset about that. But does everyone know the joke there? Reagan, as you know, was an actor, and he was in this movie, Bedtime for Bonzo. So I think it was about a monkey or something, but this poor kid was upset. But in '86, Congress amended the law as part of a drug reform package. You seem to get these every couple of years, drug reform laws. But it made it easier for federal agencies to hide information from the American people and from requesters. But in spite of these efforts by Congress to weaken the law and federal agencies to circumvent FOIA, FOIA is still a very important tool that's underutilized by journalists and activists alike. Now, how does FOIA work? Anyone here can make a FOIA request. You don't have to be a U.S. citizen. You don't have to be a lawyer or a journalist. Come on in, welcome. Hi, I'm Mike Kuzma. Just started. You don't have to be a lawyer or journalist to make a request. You don't need any special legal skills or forms. Very, very simple. Just to let you know, just to backpedal a little bit, I started making requests back in the late '70s, and at that time I was in my late teens. So I did that with no help from lawyers. I was just an angry young man. Now I'm an angry old man. So, okay, let's see here. Okay, what records are available? You can request records regarding events, corporations, deceased individuals, public figures, politicians or celebrities. You cannot, however, request Leslie Pickering's file or my file unless you have a waiver from that person. So, and even as an attorney, like if I make a request for you, I still need a waiver. Now, how long does it take to request or receive the records after you make the request? Now, in theory, the agency has 20 working or 20 business days to produce the sought-after records. Now, under the law, they can take additional time under what they call unusual circumstances. The reality is, and my primary focus is the FBI and some of the law enforcement intelligence agencies. The reality is, with these agencies, it often takes months, sometimes years to get the records, in spite of the law, say 20 working days. And there's another thing I could say at the end. If you're a journalist working on a real-time timeline, there's a way to speed that up even further. You may wonder, well, okay, I want something from an agency, but I don't even know where to send the thing. Now, all agencies have websites. For example, the FBI has, it's FBI.gov. You go to the FOIA section. You can also send requests now electronically, and I know you young whippersnappers can do that. I still prefer using mail because I'm always looking ahead to lawsuits and such. And I notice that emails get way too casual, and it gets confusing, especially if you're going to be suing or you're going to make what they call an administrative appeal. So if you're adept at using emails and electronic communications, great, but keep very accurate records. And the same holds true if you do use the old method, namely the U.S. Postal Service. Keep copies of your requests, date your requests, and make sure you keep a record. If you date something April 19th, 2015, you make sure it's mailed on that day. And we can discuss these, because all of this stuff will be important if you file an administrative appeal or if you bring a lawsuit down the road. Now, can an agency withhold records? Yes. There's an exemption for national security. There's a law enforcement exemption. They don't have to release information, for example, regarding a confidential source. And a confidential source, it's not just an informant in the traditional sense. It includes corporations, banks, telephone companies. The law allows them to withhold that information. Now, these exemptions under the law are permissive, not mandatory, which means if information falls within one of the exemptions, the agency may, but it isn't required to withhold the data. Disclosure, not secrecy, is the dominant feature of FOIA. Now, here's the national security exemption. It's what they call the B1 exemption. So if you ever request records from the NSA or the CIA, this is the exemption they specifically use. That's the exact wording. Now, the B70 exemption, this was part of that 86 amendment that I mentioned under President Reagan. And they actually codified what the courts were already doing. So they expanded the definition of confidential source or informant to include local police or state police or a private institution such as a bank or that. So I still can't get my head around that. How can a bank be considered a confidential source or a phone company? But the law allows them to do that. So that's the B70 exemption. Now, this is the other provision that was part of the 86th Amendment. And it actually codified what a court had done in a case involving the Clomar expedition. Is anyone familiar with that? Remember Howard Hughes? Does anyone remember him, the eccentric billionaire? The CIA contracted with a Hughes-owned company, and they were trying to get this Soviet sub that I forgot where it sank, but they were trying to raise the sub and then get this during the Cold War. They were trying to get intelligence data. They figured, well, we'll get this sub and then we'll learn about those evil Soviets. So anyway, someone sued for those records, and the court, this was the first time a court said that an agency could neither confirm nor deny that records exist. So if you look at the language of this statute, just say you are say you're pretty sure the FBI is looking into your activities for whatever reasons. But the FBI, well, no, wait, just say you're not quite sure. I'm not sure if the FBI is looking into my political activism. And the FBI can write back and say, we have no records, when in fact there's this full-blown investigation. So if they believe the subject of the request is unaware of the existence of the records of the investigation, they can write back and say they have nothing, when in fact they have this massive dossier. It's pretty insidious. But that's what they call a GLOMAR response, which has now been codified under this statute. So you might think, well, golly, why should I even make requests? You still don't let this scare you, because we've had quite a lot of success. So again, just never lose sight of the fact that we have a right to these records, and that disclosure, not secrecy, is the dominant feature of FOIA. The other thing is, because a lot of the stuff we request records for has to do with political activism, people being monitored just because they're exercising First Amendment rights. There's this case, Cantor versus IRS, and there's actually a similar case. We're in what they call the Second Circuit here in New York, which covers New York State, Vermont, Connecticut. There's also a case by the name of Kuzma versus IRS where they adopted this. FOIA exemptions, that is, does not shield materials relating to unauthorized or illegal investigative tactics. So if you're the subject of unauthorized probe, in theory at least, they can't withhold that information. Now, what if you need the data quickly to make your request and maybe you don't hear anything, or maybe you just get an acknowledgement letter? You could file an administrative appeal. Again, you don't need any special skills. You can do it either electronically or with a letter. Now, in theory, they're supposed to, much like the request, respond to the appeal within 20 working days. But unfortunately, that doesn't always happen. It often takes weeks, months, years for them to act on the appeal. Now, just to show you how it works, just say you request FBI files. You'll get an acknowledgement letter. So then it'll say we have your request and it's been assigned a number. Then you won't hear anything. It might be months. You can treat that as a denial after the 20 working days and file your administrative appeal. Or if you hear nothing, say you make the request, you count off 20 working days, you could treat that as a denial and file an administrative appeal, and all FBI appeals go to what they call the Office of Information Policy, which is a component of the Justice Department. And just so you know, you have the Justice Department, and then under that umbrella, you have these different components. So the FBI, Office of Information Policy, DEA, ATF, are all components of the Justice Department. A lot of people now are into this, Homeland Security. Homeland Security is watching you. Well, no, they're not. It's what component? Is it the Coast Guard? Is it TSA? Is it somebody else? You have to make sure, you have to be very specific. So what can happen after you file your administrative appeal? The agency can either affirm the initial denial. They can direct the agency to release material that was initially withheld. Those are the two things that they can do. And I've actually won some of these administrative appeals. Now, does anyone have any questions regarding any of this before I go on? You sort of got your head around it. Just for you latecomers, I just briefly told people how to make a request, how to find an agency's address. Every federal agency has a website, so you know where your request should be directed. The agency has 20 working days to respond to the request in theory, and then if they don't respond or if they deny access to some of the records, you could file an administrative appeal. And again, with the administrative appeal, You can find all that information either on websites, or if you're denied access, they'll tell you where the agency, like the FBI, will tell you where the appeal should be directed. So whenever you make your request, that's denied. You file your appeal, that's denied. Well, what do I do? You can file a lawsuit in one of 4 places: where you reside, where you have a place of business, where the records exist, or in the District of Columbia, and that's where most FOIA lawsuits are brought. So again, don't let any of this intimidate you. It's pretty simple. I was doing this stuff long before I even went to law school or college. Now, what if you don't want to sue? You don't want to file a lawsuit, but you're still sort of interested in getting access to the records. In 2007, Congress created the OGIS, which is the Office of Government Information Services, and that's a component of the National Archives and Records Administration. And OGIS reviews agency compliance with FOIA. And that's their contact information. Now, I've actually used this agency. So say you're getting jerked around by, say, the ATF. You could write OGIS, say, look, here's my request. I've been waiting weeks, months, whatever the case may be. And they'll actually be an advocate, and they'll contact the agency and see what's causing the delay. Yes?
Can you use them when you have like a dispute, like you're pretty sure? I think what often happens is you're pretty sure they're just not giving you everything.
You could contact them on that basis.
Use people to do it?
Yeah, and keep in mind, they are with National Archives and Records Administration, so they're in the history, document preservation, they're sort of information freaks, so they actually enjoy doing this stuff. So they've been quite helpful. And it only costs you to, well, they do a lot of stuff electronically, so it's just an email with a letter or a regular letter, which is what I still do. But the other thing you could do too, in addition to contacting OGIS, you can contact your representatives in the U.S. House and the Senate. And what you should do, we're having worked at the county legislature and the Buffalo County Council. There's a lot of staffers that literally have nothing to do. And we have a kid now in our office who worked for the senator out of the state of Ohio, U.S. senator. And he's a starry-eyed kid, poli-sci major. He's looking for projects. So if you write your representative in the House or your 2 U.S. senators and say, look, I made this FOIA request or this FOIA appeal, and I'm getting the royal runaround, they'll actually go to bat for you. They will write letters to the agency. And for example, the FBI, they have a congressional liaison person. And sometimes contacting your elected rep helps in getting the agency to expedite the process. And this is all to avoid the time and expense of filing a lawsuit. Now, how can FOIA be used? I'll talk about a couple of cases. But is anyone familiar with Leonard Peltier? He's a Native American activist. He's a member of the American Indian movement. In June, actually, this year will be the 40th anniversary, but on June 26, 1975, he was at the Jumping Bull property where 2 FBI agents of Joe Stuntz were killed. Leonard was framed by the FBI for the murder of the 2 agents. The murder of Joe Stuntz was never investigated, nor was that crime solved. Leonard was tried in 1977 in Fargo, North Dakota, for the shooting deaths of those 2 agents. Now, at the time Leonard was tried in 77, the government nearly turned over 3,500 pages of material and said to defense attorneys, this is all we have. So as a trial attorney, you're totally dependent upon the good faith and integrity of the prosecution. Now, fast forward to October of '79, John Privatera, a fellow New Yorker and Buffalonian, who's now in Albany, he brought a lawsuit with Mike Tiger, who's a fairly prominent attorney. And what did they learn? That the FBI actually had 18,000 pages of material, 12,000 pages were released in full or in part, 6,000 pages were withheld on national security grounds. Now, of those 12,000 pages released, there was a ballistics report that showed a gun that the government had alleged here couldn't have possibly shot the agents. So in spite of that, the courts didn't grant Leonard a new trial, nor did they free him. So fast forward to 2002, that's where I came in. We submitted a new round of FOIA requests on Leonard Peltier's behalf. As a result, we learned that the FBI has 142,579 pages of material, and it pertains to Leonard, and the FBI is big on this. They like to give their investigations names. So that was called Res-MERS, for Reservation Murders. And the Minneapolis office, which was the most important office, because that was even called the Office of Origin, had over 77,000 pages. Now, they released 66,594 pages in full or in part, and they withheld 10,555 pages. And one of the arguments they made, which the court accepted, was that they couldn't give those 10,000 plus pages because it would hamper the nation's war on transnational terrorism. We're talking about something from the 70s. It's pretty bizarre. But the case is Peltier versus FBI. It's out of the 8th Circuit. You do a Google search, you'll find it. The decision was rendered in 2009. So that was one case where we used FOIA. Now, more recently, we had Occupy Buffalo. Was there an Occupy Binghamton? I don't know. There must have been, what was it? There must have been an Occupy Endwell then, right? There had to be. So anyway, we had an Occupy Buffalo, and kids were camped out in front of City Hall at Niagara Square. And we were pretty sure they were being surveilled, plus there was a lot of weird stuff happening. Unusual people start showing up, and what have you. There was a competing Occupy. So we start making FOIA requests. We made one to the FBI, we made one to the Buffalo Police Department using the state law, and we made one to the actually Homeland Security, which sent the request to the different Homeland Security components. And the U.S. Coast Guard is one of those components. Now the Coast Guard, it turned out, had Occupy, which was on land. It wasn't floating in Lake Erie. They had it under surveillance. We got 13 pages, and there was a national, Jill Terreri from the Buffalo News did a story which was picked up nationally. But that's another case of how we use FOIA, and we were able to show how the government engaged in illegal domestic political spying. Now, a local activist, Nate Buckley, who works at Burning Books with Leslie Pickering, he was targeted by the authorities because of his activism, because he was involved with a so-called radical bookstore. But he was at a protest in the spring, what was it, April of 2011. And he gets arrested by the transit cops. And they had this insane trial where he was initially he was facing anarchy charges and all of this lunacy. And they actually prosecuted this cockamamie case. Well, it ended up in a mistrial because one of the jurors during jury deliberation, and don't you do this, wrote the judge a letter or a note saying, hey, my brother's got a DWI in front of you. Is there anything you could do to help? And it was clear this person was trying to curry favor, thinking, well, if I convict this Buckley guy, maybe the judge will let my brother off. As bizarre as that line of thinking maybe. So anyway, so getting back to this Buckley prosecution, in theory, again, like the Peltier case, the prosecutors are supposed to give your defense attorney everything, including what the cops have. Well, we know that this doesn't always happen. This is called Brady material, if you've never heard that. So there's this mistrial. Dare Irwin, another activist attorney who we work with a lot, and I got involved in the case. and we were a little more aggressive, not to criticize the fellow attorneys, but we got a little more aggressive and we made FOIA requests to the NFTA, which is the Niagara Frontier Transit Authority, and that's where the cops worked to arrest Nate. And we got 71 pages, released in, what was it? 71 pages, 42 in redaction. Now, these should have been turned over by the DA, which they weren't at Nate's trial. Well, what do we learn once we get this stuff? That the cop who pepper sprayed Nate before he was arrested was the subject of a New York State Inspector General. I didn't even know he had a State Inspector General, but he investigates this cop. Now, that was critical information that should have been turned over to defense attorneys, and it was only through FOIA that we learned about that. So and that was without filing a lawsuit. So before I go on, does anyone have any questions? Or I could briefly give you the difference between the federal statute and the New York State statute. Well, the state statute was modeled after FOIA. So FOIA is the state statute, FOIA is the federal law. The federal law, as I indicated, you have 20 working days to produce the material. With the state, they have 5 business days to, this is New York State, they have 5 business days to acknowledge receipt of the request, and then they're supposed to, in theory, turn over the stuff, I believe it's within 30 days. But when they give you that acknowledgement, they're supposed to give you a timeline and say, what, the records will be produced on such and such day. And then with administrative appeals, you have, after the record request is denied, or if you get no response at all, you can, if you get no response at all, you can treat that as a denial and you can file an appeal. So just say, for example, you were after records from SUNY, and just say you made a request to SUNY Binghamton or say the University at Buffalo. You make the request, say, to the president of the university, and then if you got the runaround, you could go, I would go to, I think he's still there, the general counsel for SUNY would handle administrative appeals. But with administrative appeals at the New York State level, they have to, you have 30 days after you're denied access to file the appeal, and in theory, they're supposed to make a determination in 10 business days. So you don't include weekends and holidays and such. And then the only other thing with the state, you have, if you file a request that's denied, you file the appeal, it's say denied in full or in part, you have 4 months to, or 120 days to bring in what they call an Article 78. Whereas with the federal law, to bring a FOIA case, it's a 6-year statute of limitations, so that's quite a difference. But an Article 78 is pretty simple to do. It's not difficult at all. And it's somewhat similar to FOIA. And again, don't let this scare you, but I brought pro se cases in the late 70s, early 80s. I took a couple up to the U.S. Supreme Court. No legal training, nothing. Just if you can read and comprehend the English language, there's nothing you can't do. You can bring a lawsuit, like I said earlier, in the 4 places where you have a place of business, where you reside, where the records are located, or the District of Columbia. Most suits are filed in the District of Columbia. And again, I'll walk you through this. Most attorneys don't do this. Most attorneys don't go in court or file lawsuits. They either are afraid to. I have friends who are afraid to, and they're attorneys afraid to go into court, if you can imagine that, which is kind of scary, but they're out there. So just say you wanted to file a lawsuit. Say you're a journalist, or maybe you're an activist working with an attorney who maybe is sympathetic but hasn't done this before. It's real simple. This stuff isn't rocket science. You go to any U.S. District Court website, and there's 2 forms you need to fill out. The one is called the civil cover sheet, and it's very simple. You just check off, there's a section, type of action, it's a FOIA case, I think the number for it is an 895, but it's fillable you can fill a fillable form, you can do it right online. So it's a one-page form, so you put the caption, so it would be your name, and you would sue the agency. You don't sue the agency head, like you wouldn't sue the director of the FBI. You would sue, like with ATF or the FBI or DEA, you sue the Justice Department. So it would be, say, Pickering versus Justice Department. So you fill out the cover sheet. The summons, all that has is you put the caption of the case, and then you would put the address of the attorney, or if you're acting as your own attorney, you would just put your name and address. That tells the agency being served who they should send the answer to. Now, if you go to the Burning Books Buffalo website, we have a sample complaint right on the website. So you just need 3 things to file a lawsuit: the civil cover sheet, the summons, and a complaint, and $400 to file a lawsuit. So petitioning the government for redressing grievances isn't cheap. Used to be $50 or no, 60 in the old days. Now, see, there's the filing fee, it's $400. Now, if you go to court in the old days, which wasn't that long ago, you could pay cash. They don't take cash anymore. You gotta either use a credit card or use a money order. It's ridiculous. If you're indigent, you can file, sometimes it helps inmates, but not so much. An inmate they give them a break on the fee. They only have to pay $350. So what is savings? So even if you get the informal pauper status, you're really not saving any money. And what they do with these poor inmates is they just, and they get paid, what, 10 cents an hour, whatever, they just deduct it from their commissary until the $350 is paid off. So once you file your paperwork at the clerk's office, you have to serve a copy of the complaint on the U.S. attorney. I don't know, is there a district court here in Binghamton? Is anyone here from Binghamton? Where's anyone? You're from Minnesota? So, and I've been there. We filed a Peltier case. There's a court, right, needless to say, in Minneapolis, but there's one in St. Paul. So we filed, at the time, what was his name, Donovan Frank. Well, we filed right there at the district court in St. Paul, Minnesota. And then you serve the U.S. attorney, like the U.S. attorney of a big city like Minneapolis. You would get a copy, serve the summons and complaint on the U.S. attorney. A second copy is sent to the Attorney General, who is still Eric Holder. You just send it certified mail, and boom, you're in the lawsuit business. Wasn't that easy? So government has 30 days to file an answer to your complaint. And the complaint, just so you know, it's simple allegations. You would say, I made a request, the request was denied, I filed an appeal, that was denied, now I'm in court. And we have it all on the BurningBooksBuffalo.com website. So the other thing is, this may sound complicated. You file your lawsuit, you get an answer from the government, you file a motion for a bond index. Again, we have that because we like to help folks at Burning Books. But we have a sample bond motion and a supporting memorandum of law on the website. So if you have a sympathetic lawyer, he or she doesn't even have to think. We got it all there for them. And you file the bond motion, and what the government has to do is prepare what they call a bond index. Now, you may wonder, well, how did it get this name, Vaughn? Well, Vaughn versus Rosen is a case out of the District of Columbia, where the court for the first time ruled that agencies have to come up with these indexes, and there are agency affidavits where an agency official has to explain why a document or portions thereof are being withheld in full or in part. So you file a complaint, government answers, you file your bond motion, the bond index is filed, then what happens? There's no trial, there won't be a jury, there won't be any of that. It's all done generally on the papers, but you'll file a motion for summary judgment, and all it is legal arguments as to why you're entitled to the records. Usually what happens at the federal level is that the government will file for summary judgment saying, hey, records are exempt in the case law. Other courts support our interpretation of the law. And then all you do is file counter arguments as to why you think the record should be released. And it's a pretty simple process. And then what happens after the court has all these legal papers, it may or may not hold oral argument. The courts are getting away from that. A lot of times they just rule based on the papers that are filed with the court. But the court or the judge has the power under the law to order the agency to turn over the records, and then the judge can look at them and decide whether or not they should be released. Now, we've had this Judge Scrapney who's on what they call senior status, which means he's retired, but he can take as many or as few cases as he likes. I had him sit on one page in the Peltier case, because and you wouldn't believe the crap they went through. They had some guy from the Justice Department with national security clearance come with an attaché case with this one page, and he looked at it, and then he thought about it for 250 some odd days as to whether or not it should be released. So the federal judges can take as long as they want to render a decision. This is just some other stuff. Now in theory, and I'm assuming most of the people there are activists of some sort or another, and we all have a right in America, in theory, to petition the government for redress of grievances and to say whatever we want and to have meetings and what have you. So we have this right, and the Constitution, in theory, is the supreme law of the land. And then here in New York, we have companion rights. If there's any New Yorkers here, we have Article 1, Section 8. That's the parallel to the First Amendment to the Constitution. And Article 1, Section 9 is also talks about petitioning the government for redress of grievances. Now, in theory, the Privacy Act, which was passed around the same time the FOIA was amended, states that an agency shall maintain no records on how an individual exercised rights guaranteed by the First Amendment. Now, do we believe the federal agencies don't abide by this? And most people don't even know that, in theory, an agency, if you're speaking out publicly on an issue, the agency isn't supposed to maintain records on your activities, but yet we know that they do. Here's some useful links. But a lot of times in the cases I'm involved in, whether it's Dave Buckley or Leonard Peltier or Occupy, people are exercising First Amendment rights, but yet the federal agencies are monitoring these individuals in contravention of E7 of the Privacy Act. So one of the arguments I made is that the investigation by these agencies was illegal and unauthorized and initio from the beginning, and that they can't use FOIA exemptions to hide illegal or unauthorized investigative tactics. Goes back to that Cantor case that I mentioned earlier. But in theory, these agencies aren't supposed to monitor your First Amendment activities, but they do. But these are some useful links you should go to. I think we have a lot of, do we have the links on Burning Books Buffalo? Yeah, we have a lot of this material. But FOIA.gov is run by the Office of Information Policy. FOIA Advocates is attorneys in Oregon. That George Washington University.edu, that's the National Security Archives. They do great work with FOIA. We just had Sunshine Week, Associated Press and others focus on FOIA and how it's being trampled upon by various administrations, including the Obama administration. Access Reports is a friend of mine, Harry Hammett, has a book and he publishes a newsletter. But they have a lot of good info. RCFP is Reporters Committee for Freedom of the Press. They have a guide. They also walk into a lawsuit. I actually, if you need If you have any FOIA questions, you can go there, or you can go to Prairie Books Buffalo, the FOIA section, or michaelkuzma.com. But does anyone have any questions, specific questions? Yes.
Yes, thank you for all of this information. My first question is, first, first, can it be harmful to do these requests? I'm wondering, can you just like, when you ask for these, a red flag or something, and they will start investigating?
They're not going to ask. Somebody asked that earlier. I do know, because I was thinking about it during the break, there was an uptick in requests after the Snowden revelations. NSA and various agencies noticed a huge increase in the number of requests. So if you think about it, are they actually going to investigate all of these people who made requests? They're more focused on what they call the prolific FOIA requesters. I think Ryan Shapiro, an activist out of Cambridge, he's deemed to be a prolific requester, and I believe I am. I think Leslie now might be in that category. So I wouldn't worry about that. I've been doing this since the late 70s, and let's assume for the sake of argument that they are. Big deal, who cares?
And usually what kind of information did you get out of this recording?
Like, we showed some of the documents we got in Leslie's case, but we've gotten reports, police reports, ATF reports, like the Vaughn Index, even though that's something that's filed with the court, that gives you, even if you don't get the records you're seeking access to, it gives you an idea of what they do have and what they're withholding. So we've gotten all kinds of stuff. In my case, there's a book called The Law Unto Itself by David Burnham. In chapter 4, it talks about how, as a teenager, I wrote a letter to the editor of the now defunct Buffalo Courier Express, bitching about income taxes or something. Now, did I know that the IRS did and still has something called the Publications Monitoring Program? So what they do is they have agents, at the time, this is pre-computer, they would read newspapers and articles looking for anyone who was even hinting that they were fed up with the taxation system. So they would clip out the newspaper article and put it on a form called the newspaper clipping guide. And then they would start a probe based on that. So I've gotten that information. What else have I got? With Occupy, what did we get? We got the Coast Guard stuff. Well, the FBI claim they only had 5 pages, which a court recently ruled. And then, like I said, with the Nate Buckley case, we got stuff. In the Peltier case, we got some pretty, I thought we actually had the samples of some documents. Maybe this is an old one. Yeah.
I could talk a little bit about what we got in my case just real quick. We used federal law FOIA against the post office, which was had an inner mail cover, which photocopies the outside of your mail as it comes in. And so we got, from them, we got photocopies of all the mail during that 30-day period that I was under the mail cover, that I had evidence that I was under the mail cover. So that's another thing, is like, they'll deny it if they can, but I actually had evidence of it.
So they were monitoring the outside of your mail?
They photocopy the outside of your mail, yeah, to see who you're corresponding with. So I got photocopies of all that mail, you know, that I had already received, but it showed that they were copying it. And then we appealed, and we also got the cover letters that they were putting these things in weekly bundles and sending them off to a special office at the Postal Inspection Service, and then processing off from there to whatever law enforcement agency was requesting the copies. So that was with that. With TSA, we got incident reports. I was put on a secondary security screening selection list. That's like called a selectee list. It's where you are like pulled aside at the airport and given additional security screenings. So I had evidence of that as well. It was on my ticket. So from there, we got the incident reports of what happened when they screwed up during that process one time and forgot to put it on my ticket, and there was this whole incident in the airport. I went over all this at the previous. Sorry for those of you who were
Oh, sorry, I was
at the thing, but
So when we could quickly pull up, we could show you some samples of what
then you
we've
can look
got.
at the stuff, yeah.
Yeah, because we're pretty much done with this.
Just a second.
Was there another did somebody else have a question while we're pulling this up?
I have some very specific
Yes.
questions.
Lay 'em on.
Okay.
I am on.
Okay, so I've been attempting to use FOIAs for a long time
Okay.
for various reasons. And one of my issues is that, well, I'll start with a specific question. Is it possible to get information from a city attorney, or are they just gonna redact it all and say because they're an attorney, there's privilege there?
You're talking what, here in New York State?
We're actually talking about in Minnesota.
So you're using the state statute?
We would have to use the state statute.
You have to use the
so-
state statute. What they're probably going to do, and they're going to use the intra-agency exemption, is my guess.
Even if it's like because we basically saw a document
Yes.
that shows that the city attorney had direct communication with the police department and with the target of our protest, and they decided to create a situation where they could prosecute us, where they had the police tell us something, position us somewhere, and then they charged us, right? So we just happened to, luckily, people were flipping through things, and Kim was smart and had her camera, it was
Yes.
snapshot, and we found this email, right? And so it's an email like, Mom and Dad, I contacted the city attorney, this is what's happening. So we don't know if we should spend our time or money because it's an attorney, but it is a state attorney, so we didn't know.
So it's the state attorney general, not this, because
It's the state attorney.
Yeah, because in Buffalo, they call them the corporation council, so is it?
Okay,
So it's the Minneapolis Corporation Council. The way I would attack that is I'd make the request to the law department for that specific, maybe a time frame. I'd say I want all communications between the police and your office between whatever, say
Okay.
May of 2012. And at the same time, I would also hit the police department or whoever else got that email. Because I'll give you a good example in Jaleel Muntakim's case. We tried to get a letter that the New York County DA sent to the Division of Parole opposing his parole bid. So the Department of Corrections said, oh no, you can't have that document. It's a 4-page letter, they claimed it was. So I got a date, it was May 16th. 2012. So while the case against Docs was pending, I made a FOIA request to Cyrus Vance Jr., the New York County DA. He produces a heavily redacted version of the letter and tells me there's 38 exhibits, or 30 some odd pages of exhibits, which he gives me unredacted. So the lesson to be learned is that what I would do is hit all these, I'd hit the cops, I'd hit the corporation counsel. And they're probably going to come back with that whole interagency thing saying, you know, it's privileged. And then you would have to make arguments on your appeal, or if you did go to court, as to why that exemption is inapplicable. But I would hit them all. And I can't imagine, because Minnesota is what's supposedly a progressive state. If it's anything like New York, those cases are easy to bring. They're very simple.
so,
You'd have to find out, like in New York, it's called an Article 78. It's just a petition and notice of petition. You could do it on a shoestring budget.
so can you get stuff like from the court? Like you say it's progressive, but like weird things keep happening, like a restraining order got filed, but there was no court hearing.
Well, in theory, they're supposed to, even if they get a TRO, they're supposed to, temporary restraining order, the parties, the people who will be impacted should get notice at some point so they can appear and argue their case.
Right, so that didn't happen, so we're wondering things like, can you use, like, we have a 2-year restraining order, never notified till, like, after it had been issued for like months.
Is there a
right?
docket number? Go down and pull the court file.
But is there a way to find out any extra information
Well, in
besides?
theory, see, the bad thing about this electronic court filing now, it's easier for them to hide stuff. But if Minnesota's still filing stuff in paper form, just go right down to the clerk's office and pull the file.
So you gotta understand too that what you're requesting isn't just information, it's actually specific documents. You can't just have a question and say like, well, how did this thing happen? You have to figure out how to answer your question by requesting documents. Like Mike was saying, request all communications between these two agencies, which happen to be the two parties that would have to talk in order to make that decision.
So that's my other question, is how do you word things accurately? Because I filed so many FOIA requests and they're like, there's nothing, and I know it's because I didn't say the right
You
thing.
can't just be like, do I have an FBI file? There's my
So,
story.
but are
That's
you,
the one.
in your request saying you could say I want everything relating to me, my request specifically includes but is not limited to, and then you could say I want the memo from Assistant Corporation Counsel Smith to Police Chief Jones. So you would add that line in.
Okay.
So that's how I would do it.
You can see some of this here too, like this is what I was talking about.
These are, going back to your question, this is
The
a
post
sample
office.
document. These are the actual letters they photocopied.
It's just like random stuff I got in the mail. It's like student loan bill, Amazon.com, it's like Tombstone Engraving Company I was dealing with, and nursing home I was dealing with my grandparents. And it's like a piece of legal mail, just a water bill, just some normal stuff. So they sent these back to me, and then we appealed saying that that's not all we're asking for. Why isn't this including, why isn't the application for the mail cover included in this packet, not just photocopy of the same mail I already received? So they sent us a little more, although still not everything. And they sent us that they put these things into weekly packets, and put a cover letter on it that would be sent to this office, which is part of the U.S. Postal Inspection Service in Chicago, where apparently they process out these mail covers and send them off to the law enforcement agency. From there, also it says on here, compromise this mail cover may result in disciplinary action. So they were concerned about people finding out about these things. This is from the TSA about the being on the selectee list, which I mentioned briefly. These are the incident reports. It talks about what happened at the airport where they screwed up with not having the designation on my ticket, and I figured it out and caused a big scene. We got this using the state law in Oregon against the Portland police. It's a document that talks about I had sold a car right after I moved from Oregon to a friend who lived out of it somewhat, and they found it in the middle of the night with a bicycle leaning against it, and this person sleeping inside who they thought was me. They ran the license plate number, and this LEDS hit came up, which is kind of like an ABB, just kind of like they scan, and then, oh, this car belongs to this scary person. And whatever that is all blacked out right here. So the car was still in my name while this other person was sleeping in it. So they thought it was me, and this information came up, whatever it is, caused them to contact the FBI. So that, we never knew anything about that before. Also from the Portland police, we found out that the first time I was ever arrested in October of 1996 at an anti-vivisection protest in Portland, Oregon, that 11 people were arrested, including me, and that in the arrest report they listed us all as associated with the Animal Liberation Front, which if you're familiar is considered a terrorist organization by the U.S. government. So here we are, sudden free speech, protest, yet we're being associated with a terrorist organization, alleged, which I don't think is a terrorist group or whatever. We applied to this Justice Department, or the ATF, which is the Bureau of Alcohol, Tobacco, Firearms, and Explosives. It's like the FBI's nasty little brother. And at first they said, we're not going to give you anything because we have an open investigation. We filed the lawsuit. When we filed the lawsuit, the FBI admitted, and that's what they're saying here, that they were behind the mail cover. So in court, this isn't even something we got before. This is something that was released to the court, a court document where they just openly admitted that they were the ones who got the post office copy of our mail. Then the ATF all of a sudden dropped its song and dance about not giving us the pages because they had an open investigation. Instead, they gave us 187 pages. As soon as we filed a lawsuit, then they started obeying the law. It included a lot of stuff. This is a document about when they raided our house one time, a conversation that we were having, which I'm not going to go over, but it's kind of funny. Where basically, they heard one of my roommates whisper to another roommate to get some cookies. They thought it meant computer cookies, like incriminating information on the computer, but it was actually talking about, as you can see, they mentioned the word bakery 7 times in the next paragraph. It was actually talking about chocolate chip cookies that were being heard at that point in a car that they were raiding. Here, what is this one? Oh yeah, here, so it's an ELF, the group that I was affiliated with, well, the underground group that I was running the press office affiliated with, released like an anarchist cookbook type of manual telling people how to make fire bombs, whatever. And the ATF decided to see if it was a violation of the specific penal code, which talks about distribution of information related to explosives, destructive devices, and weapons of mass destruction. So they're taking this thing pretty seriously. Here's something that is kind of typical of what you might get. This again was from the ATF documents. This is what they call a confidential source page. So what they're saying is that on this date, which is probably near April 18th of 2002, somebody who they're not going to tell us who it is met with me and provided these 4 pieces of information. Again, they're not telling us what those 4 pieces are. Basically, an informant of some kind met with me on this date and then reported back to the FBI and told them these 4 things. They also included a DMV photograph of the informant, which they didn't share with us the picture of. You know, we're working on trying to get these things cleared up in court through an appeal, but we have 2 of these just in the ATF documents where there's 2 different informants in a situation like this. That's pretty typical of the kind of thing that people are looking for when they're trying to get FOIA. And there's other documents earlier on that we talked about too. We've gotten a lot more than that, but the more you fight, the more you get. And we wouldn't have gotten anything if we didn't sue.
They tell you what they're not getting you, like they say.
That's what they're
not
doing.
giving you
That's what the
X
Vaughn,
number.
that's what's great about the Vaughn Index. They have to describe how many pages are being withheld and why they're withholding data.
So as of right now, we haven't gotten any FBI documents, but they have told us that they have over 30,000 pages.
Wow.
So, and they're supposed to be releasing them by court order over the next
Every
years.
120 days. What about the Minnesota Coalition on Government Information? Are you familiar with them?
No, I just moved to Minnesota and.
Yeah, because I got their website just looking quickly.
Minnesota Coalition.
Yeah, I guess the website is mncogi.org.
Thank you.
What I would learn, it's got to be fairly simple to file one of the lawsuits, because you'll probably make the request get denied or ignored. If there is anything like the city of Buffalo, you'll be ignored. You file the appeal, you get chirped around or ignored, then go right into court. That's what I would do.
Thank you.
Here's another document that we did get through from the Oregon.
This is
Oregon State
the,
Police.
leaves the state statute in Oregon. You got this. And notice they didn't even redact the name of the ATF agent. That would never happen at the federal one.
Yeah, so we had gotten this. This is a document about an ATF agent and an Oregon State Police agent trying to serve grand jury subpoenas of 2 households. The first paragraph is about Acta's household that's about 6 blocks away from where I was living. The second paragraph is about the household that I was living in. They were trying to serve me with a grand jury subpoena. So, you know, because we got this through the Oregon State Police, they did a very sloppy job. They probably had some intern do it or something. It's just like, they redacted almost anything. In fact, this redaction right here is clear right here. They just didn't even cover it up. They didn't take the time to pay attention that that address was like in the same paragraph. But it specifically talks about, like, it shows you how people resisted the grand jury subpoena. Aston's had a warrant, she slammed the door shut. Same thing down here, approached the residents. Talks about how me and someone else left the building from behind on bicycles right as they were coming up. Closed the door and never returned. All this kind of stuff. So, you know, you get like pretty detailed information if you try to. And when we did the ATF FOIA request, they didn't provide us anything on this. Absolutely nothing. So now, because we're coordinating between the 2 agencies in our lawsuit, we're going to be able to bring this document up in court and say, you know what, ATF didn't comply with FOIA because they didn't put anything about this on here, but we got it from Oregon State Police.
And do you get a sense that they are tracking who's requesting things? Because I use the Minnesota state law to get all the traffic tickets in my city so my students could do a racial profiling study, right?
Okay.
Super easy. I've never had it even be that easy, and they're handing over, I mean, personal information, like people's DMV records for hundreds of people. But when I want to find out about animal experimentation at the U of M campus and I want any records pertaining to monkeys, suddenly you would think that that's less sensitive information, but it's like nothing gets replied to, nothing gets replied to. Do you get a sense that they're tracking what's coming in, or that it's just simply like the agency, like my police department maybe doesn't care, whereas the U of M is more used to this, and so they
I
do
think
care?
it depends on the staff person handling the thing. One person might have a more liberal attitude than might be more, aware, more adverse to FOIA, and you might have someone who's just out, somebody who's out for lunch.
So does it make sense to have maybe two people file and
You might
we
want to get different
someone on a
people,
different
because
day?
like after a while, you'll get identified as being a prolific requester. I think a request coming in now from Leslie or I get treated a little differently than, say, someone else.
Mike, does his own attorney letterhead, which I think get common, and he calls up, he'll like call them up, like with, Portland Police and Oregon State Police, like he'll call them up, say, hey, I sent you buddy with them, and then all of a sudden they'll release some documents. So, just go out there and try to do as much as you can. I would add this.
Yeah, I think we're running out of time. But, yeah, we'll be here for lunch if you have any other questions. But I would just keep plugging away. I've been doing it for over 30 years. And, yeah, I'd like to see more people doing it and exposing these agencies for what they're really all about.
Thank you.
But thank you.
Like one of you. I've actually never tried that.
Just been occupied. And there's some cases that we